The defense attorney kept calling me every week. Why? Because he kept wanting to settle this case. So I kept asking him, so what's your offer? Oh, no, let's speak to the judge. Let's have a pretrial conference before I give you my offer. And he said, but before I do that, I need to know your demand. Do you want to know why this was all a bunch of nonsense and why it meant absolutely nothing? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The case was getting close to trial. The defense attorney kept calling me literally every week. Said, listen, we really want to settle this case. This is something we'd like to get rid of. We'd like to move. I said, so go ahead and make an offer. They said, no, we need to know what your demand is first. Okay, so now I made a demand. It was in the mid 6 figures. And now I said, make your offer. He said, no, we want to speak to the judge. We want the judge to try and negotiate a settlement. I said, okay, fine. So we asked the court for a pretrial conference to try and settle this case. The defense was eager, very eager to try and settle this case. Now, what does that mean? It means that the defense recognized that they had a problem. It means that they would rather enter into a business decision to try and settle this case before trial rather than letting this case go to a jury and now risking the unknown. You know, you may not be aware, but when a case goes to trial in a medical malpractice case, an accident case, or even a wrongful death case in New York, neither side knows what the outcome is going to be. There are risks associated with going to trial, and the risks apply to both sides, the plaintiff, the injured patient, the injured victim, as well as the people who are being sued. So now, we finally get to court. Now we have a conference with the judge. We sit down, we describe to the judge what the issues are, we tell the judge what our strongest points are, and now the judge tries to browbeat each of us before he actually gets a number from the defense. When we sat down with the judge, one of the first things the judge wanted to know was, what was our demand? And I told the judge, this was no secret, I told the judge what our demand was. Now, he sends the defense attorney out, and he says to me, okay, what's your real number? Now, that's a loaded question, and it's a very dangerous question. Now, why is that a loaded question? Why is it a dangerous question? Because if the judge takes that number and now goes back to the defense and says, okay, this is what Oginski needs to settle this case, guess what? If he says no, now I'm screwed. That's a problem. Before I even lowered my demand, I said, Judge, I need to know that the defense is serious about trying to negotiate this case. They've been telling me every single week that they want to settle this case. They tell me that this case should be settled. And now I need to know that they made a good faith offer to go ahead and settle this case. I want to see serious money being offered. He says, fine. So now he goes and speaks to the defense. And then after a few minutes, he calls me in. The defense goes out. And now what happens? The judge tells me that they would seriously consider offering what they called nuisance value. And I looked at him. I said, nuisance value? I said, you must be kidding me. In case you don't know, nuisance value is simply a small sum of money designed to try and get rid of the case, to hopefully pay for, the expense of litigation, and that's pretty much it. A small amount, a nominal amount, just to get rid of the case because they have so little regard for the case as well as the value. That was their good faith offer. I said to the judge, there's no point in talking any further because it's obvious that they're not serious. They have no intention really of trying to settle this case, and they've been jerking us around for months now, telling us and promising us that this case should be settled and needed to be settled. The judge said, let me see if they have any real money to offer. So now after 10 minutes, I'm told to come back in, and now the defense attorney is still sitting there. And you know what the response is? The judge tells me they don't have any more money to offer, and I'm setting this matter down for trial. Now, what does this all mean? It all means that the defense was pulling my chain from the very beginning. It means that the defense, every time they kept calling me to tell me that they wanted to try and settle this case, it was absolute, total, okay? That's what it was. And they had no interest whatsoever in actually trying to settle this case. The only way that this case would be settled, according to them, would be if, look at that, hi baby. I'm walking by a dog park. The only way that this case would be settled, according to them, would be for a nominal amount. And you know what they considered to be a nominal amount? $10,000. The fact that they felt this case was worth only nuisance value, to them $10,000, was not only insulting, it was absolutely offensive. So why do I share this quick information with you? I share it with you that just because the defense says that they're interested in trying to negotiate does not necessarily mean that they're really serious about trying to do so. Maybe they're trying to do what this defense attorney did, which is to get this case to go away by offering a few dollars, and hopefully you get some plaintiff's attorney and some plaintiff to turn around and say, you know what, let's take the few dollars rather than go to trial and call it a day. No, that's not what happens. So you turn around and say, that's fine, we'll see you at trial. And we'll let 6 members of the community decide whether we are slightly more likely right than wrong, than what we are claiming is true. And then we will have a jury decide how much money you are to receive as compensation for all of the harms and losses and damage you suffered because of their carelessness. I realize you're watching this likely because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.